The docket for the afternoon. We're going to begin with the first appearance docket, and then we have some hearings that has to be addressed. When I call your name, please come up to the podium, and we will address each person individually. If you have an attorney, we will be able to speak with that attorney if you let us know who that attorney is. Counselor, good afternoon.
Good afternoon, Your Honor.
I see you standing at the podium, so.
Jawad Hassan, Your Honor.
Okay,
Jawad.
I have it. Here's a reset from this morning.
Yes, Your Honor. Your Honor, I said we waived reading the charges.
Okay,
We all know what the charges are.
all right. I do find probable cause on all 8 counts. We need to address the bond.
Did you say?
9.
9 counts, yes.
Oh, you're right. 9.
Oh, you want to? Your Honor, Mr. Jawad is a U.S. citizen. He has ties to the community. He has practically no ties outside. Although he has a relative living outside the country, he himself, he cannot leave the country. He's here. He obtained his citizenship. If we can go sidebar, I'll explain it. But would you like to?
Okay. Okay. No, that's fine.
So he would not be leaving the U.S. jurisdiction. So we ask that you impose a reasonable bond, Your Honor. As of now, we ask that if you can set each count for $5,000, and we understand GPS monitoring, and I guess he won't be returning to his own job. So.
Okay. Counselor, I'm sorry, I don't know if you, you said your name on the record.
Lawrence Hashish, Hashish.
Okay, thank you.
Thank you, Your Honor.
State, you wanted to say something?
Good afternoon, Your Honor. ASA Islam Dashush on behalf of the state. I'm requesting on each count $50,000 bond. I'm requesting that there'll be no return to the gym, that he should have no contact with any child, any children, that if he was released, he'll be placed on pretrial level 1 with a GPS. I'm requesting that he has no electronic access at all.
Under $50,000 each count would be tantamount to no bond at all. We know he cannot afford that. So we ask that we have no problem with imposing the other conditions, but $5,000 each count.
Okay, I do find probable cause, and, you know, of course, the allegations here are concerning, and so I am going to impose a bond of $15,000 on each count with GPS monitoring, and Mr. Jawad should have no internet access, no electronic device that gives him internet access. All right.
And Your Honor, just that he can be informed, I don't know if he's still working at that gym, that he should have no return to the gym and no contact with any minor.
No return to the gym and no contact with minors. Thank you.
Thank you, Your Honor.
All right, you're welcome.
She said no electronic devices, right?
All right, let's go back to our first page. Stefan Mason. Mr. Mason, good afternoon, sir. You're before the court for an out-of-state felony hold. You will be before the extradition court either Tuesday or Thursday of next week, okay? Good luck, sir. Brandy Banks.
Miss Banks, come on up, please. He's approaching.
Ms. Banks, you're before the court for 2 counts of misdemeanor capias on a prostitution, 2 prostitution counts. You failed to appear in court 2 times. I do find probable cause. What does Ms. Banks wish to do?
Judge, in speaking with Miss Banks, she wishes to resolve both of these matters today.
Okay. All right, state.
Your Honor, the state's offer would be an adjudication, 10 days in Broward County Jail with HIV testing.
Judge, we're going to be inviting, I believe if I heard correctly, adjudication 10 days with HIV testing. Of course, we don't have an objection to the HIV, that's by statute. But we're going to be asking the court to enter into, or inviting the court into plea negotiations. In exchange for her no contest plea, she's going to be foregoing her right to a trial. She's accepting responsibility on these 2 offenses. So, Judge, we're going to be asking the court to consider extending an offer and adjudication time served.
I'll grant that. All right, ma'am, please raise your right hand. Do you swear or affirm to tell the truth?
Just listen to the judge.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Put your hand down. Okay. Do you understand what's going on here today? Do you know what we're doing here today?
Yes, ma'am. Yes, ma'am.
Is there anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
And do you understand that you have a right to go to trial, but by taking a plea today, you're giving up that right?
Yes, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, you could be subjected to immigration changes?
Yes, ma'am.
All right. What plea do you wish to enter, Ms. Banks?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. I'm going to sentence you to adjudication and time served. Do you understand?
Yes, ma'am.
I'll give you 6 months to pay your court costs. Good luck.
Thank you.
A Spanish interpreter is present, Your Honor.
Thank you.
Judge, I need 2 gentlemen that require the assistance of Spanish interpreter. The first one is on your afternoon docket on page 7, and then the other gentleman was the recall with, I believe, Mr. DeCobo.
Mr. DeCobo?
No, the attorney? Oh.
There you are, okay.
So I know, who do you wish? Oh, there's Mr.
All right.
DeCobo right now.
So,
Tu
Mr.
abogado, el licenciado DeCobo. Yeah.
Hey Wilmer, how you doing?
How you doing?
¿Cómo le va?
Judge, let me get to the chase on this one. I think we're going to need to have a little bit of an investigation on this. But briefly, my name is Richard DeCobo on behalf of Mr. Gambo.
Good afternoon, Mr. DeCobo, but we
Thank
have a
you.
Spanish interpreter, so you're going to have to go a little bit slower.
Okay. Mr. Gamboa was prosecuted, entered a plea in a statewide prosecution in case number F15. This is a legal argument. Can we raise this?
If they can turn the mic off over at the main jail.
Yes, Judge.
Thank you.
I'm sorry.
Okay. No problem. No, it's not your fault. Judge, Mr. Gamboa was prosecuted in a statewide prosecution case F15-17315 The statewide prosecutor in that particular case asserted jurisdiction for the purposes of that criminal conspiracy in actually Dade, Broward, and Palm Beach counties. My suspicion is that this particular case was named as a count in that particular statewide prosecution. And if that is the case, jeopardy obviously would have attached. He pled to this particular act or transaction. So jeopardy would have attached. I just need to see the actual complaint to see if it lines up with the charges in that particular statewide prosecution. I can hand to the prosecutor right now, and a copy to the, well, I need one copy for myself, but maybe I could hand this to the prosecutor with the court's permission. This is both the amended information charging Mr. Gamboa in that statewide prosecution case.
All right, so.
And the judgment. And
so,
Mr. Amashi, by the way, who is the statewide prosecutor on the case, will confirm everything I'm saying. And number two is this: Mr. Gamboa has already done his time, so this is dead time for him. All he wants to do is go back to Venezuela, his home country. Let me pass this.
So have you reached out to the statewide prosecutor?
Yes.
I mean,
He's cognizant of this, yes. Well,
so what's the response as far as these two
well, first, no.
counts?
Well, let me explain myself better. That would probably be a misstatement. Mr. Amashi and I have had plenty of conversations on this, but I only found out about this particular prosecution at approximately 11:45 today. Okay. Now, there was the same issue arose in Palm Beach, and that case was no action as a result of my jeopardy motion in the Palm Beach case. Mr. Amashi was obviously called the prosecutor and said Mr. DeCobo was right on that particular case. I suspect, but don't know yet until I see the actual complaint, that the same would hold true here. If this is a named count, I'll call Mr. Amashi. I can get him on the phone right now if you'd like.
Right, because that was going to be my next question.
Right,
why don't,
right.
If that's the issue, why don't we go to the source, get the answer, so that we can just.
Well, hopefully
I don't know.
My reputation is pretty good. I'm hopefully that I would be the source, but I'll go to that source too.
No, well,
I'm being facetious,
no,
Judge.
no.
I know that.
Right.
I'm being facetious. That was a joke. In any event, I still need to see the complaint though to make sure I'm right.
Right. Did you ask the
Okay,
state for a copy? Go ahead.
Okay,
No.
thanks.
I'll give you time to do that. Well, who's the next person that we have that needs a Spanish interpreter?
Judge, he is on the afternoon docket on page 7 of your docket.
He went. Yeah.
And his name is Antonio Hernandez.
He just wants a copy of the information to.
All right.
Judge, this is Antonio Hernandez on page 7.
Pues aquí tenemos a Antonio Hernández en la página 7.
All right. Good afternoon, Mr. Hernandez.
Muy bien, buenas tardes, señor Hernández.
Sir, you're before the court for one count of DUI.
Caballero, usted está ante el tribunal por un cargo de DUI, que es conducir intoxicado.
And count 2 is refusing to submit to our DUI test.
Y el segundo cargo es por haberse rehusado a someterse a la prueba.
Okay. I do find probable cause.
Encuentro causa probable o proceder.
And I've
Judge, nothing to add from the defense. My understanding is his family is going to post his bond.
Entiendo que su familia va a postear una fianza.
And I've been advised that his bond has been posted.
Y se me acaba de decir que así ha sido, que le han posteado la fianza.
Okay, good luck, sir.
Buena suerte, caballero.
Is there anyone else who needs a Spanish interpreter?
Not here at Maine, except the
We're still waiting for Mr. Gumbo. All right.
Mr. DeCobo.
Okay. All right, thank you. Bridget Campo?
Judge, she bonded.
Okay. Zoe Mizell?
Ms. Mizell's in North Broward, Judge.
Good afternoon.
Judge, I've not seen
You're
the report on this. It's not in Odyssey, and it's not in my packet that I received from the clerk.
All right. Does the state have an extra copy for Mr. Reedy?
You don't have the probable cause affidavit?
I don't.
All right, you can share mine.
Okay. Give me a moment, Judge.
All right.
The key to it, the right there. That's the key. Where the key to that is, and I make her understand.
Judge, the next person that I believe the court's gonna call is Davina White, and my understanding, she bonded, so I don't know if,
Okay.
the court was already aware or
It wasn't.
confinement status told you.
All right, thank you.
You're welcome.
What are you asking for? You want to see her priors? She has them.
She's being supervised in court by Judge Bristol.
Okay.
She's also got guardianship and all that stuff. This one thing was court. I spoke with her aunt a little while ago.
Okay.
All right, can we proceed on Ms. Mizell?
Yes, we can, Judge. The probable cause affidavit was pretty much exactly what Ms. Mizell said it would be.
Okay, so there's count 1, neglect of child without great bodily harm. And I do find probable cause as the bond.
Yeah, here's the situation, Judge. This happened back in December of last year.
Okay,
And since that time, Ms. Mizell has been doing very, very well. From what her aunt tells me, I spoke with her aunt before court. Her aunt tells me that Zoe was doing very, very well all the way through her pregnancy. Then, unfortunately, after that, she had some problems. As the court's aware, the essence of the allegation is that she overdosed on drugs and her child was present. Since that time, she has been doing very, very well since her arrest, not since her arrest, but since that incident. She's currently in dependency court being supervised by Judge Bristol. She's also being supervised in BARC. She has an IOP in BARC. ChildNet is keeping an eye on her to make sure she's doing the right things. She has to report to BARC 3 times a week, which she's been doing. And she's going to NA or NA meetings on a daily basis. And this is not just what Ms. Mizell has advised me, but also very much what her aunt has advised me. Her aunt currently has the child. Ms. Mizell is currently living with her grandmother. She's been a resident of South Florida since 2017, but she did live here before that for many years. She's working as a waitress. She's had the same job since November of last year. She makes about $250 a week. I'm going to be asking the court to consider, since she's being supervised by other aspects of the judicial system, I'm going to ask the court to consider an ROR for Ms. Mizell. She has essentially no prior criminal history other than this.
Your Honor, I've read the PC carefully. I do see that she did allegedly overdose. I'm going to be requesting a $7,500 bond. However, if the court is inclined to releasing her and not put her with a bond, I'm requesting that she be placed with a pretrial level 1 and continue the BARC evaluation and get the help that she needs so she can get her life back together.
I am going to ROR her. I am familiar that when you're in dependency court, there is a lot of supervision. So I am not going to add any more. She is under supervision of the judicial system already. So I'll ROR on this count. Good luck.
Thank you, Judge. Keep track of your court dates, Ms. Mizell. Do not miss court. Right?
Yes, sir.
Okay, good
Thank
luck.
you. Thank you. Yeah, I did
You're
say thank
welcome.
you.
You're welcome. Willie Simmons.
Mr. Willie Simmons. Bonded, Judge.
Okay. Yes.
Since Mr. Gamboa might be addressed later and.
Certainly, certainly. We'll have to call back for you, but that's, okay, thank you. Michael Perone.
He's here present, Judge, I mean.
All right, sir, you're before the court today for one count of resisting without violence, and count two is a civil writ, which is not for magistrate, and the amount is such a poor $500. So I do find probable cause.
Judge, in speaking, Mr. Perone, I told him as far as in count two, the child support, the
Yes.
purge amount $500, this court can't do anything. But in reference to count one, Judge, in speaking, Mr. Perone, he wishes to resolve that matter. We're going to ask to see if there's a plea offer on that count.
Okay, State.
I'm just seeing if he has any priors, Judge. But on that, time served would be fine, Judge.
All right. Mr. Perone, the offer is adjudication and time served. Is that what you wish to do?
Yes, ma'am.
All right, please raise your right hand. You swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Do you understand everything that's going on here today, Mr. Perone?
Yes.
And is anyone forcing you to resolve your case?
No.
And do you need more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No.
You understand you have the right to go to trial, but by taking a plea, you are giving up that right.
Yes, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it will subject you to immigration changes?
Yes.
All right. What plea do you wish to enter, Mr. Perone?
Say guilty. Is it guilty? Guilty or no contest? Yeah, guilty.
All right. I'll accept your plea, and I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir.
Thank you.
All right. How about William Dowell? William Dowell?
Is it William Tidwell?
William Tidwell. That's right. Sorry.
Yeah, Mr. Tidwell. Come on. He's here, Judge, with me.
Mr. Tidwell, you're before the court for one count of trespassing, and the court finds probable cause. What does Mr. Tidwell wish to do?
Judge, in speaking, Mr. Tidwell, he wishes to resolve this matter today.
State, you have an offer from Mr. Tidwell?
Time served, no return, Judge.
All right, Mr. Tidwell. What do
He
you wish
wishes
to
to accept the state's offer, Judge.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down, sir. Do you understand the proceedings you're in today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
And do you understand, Mr. Tidwell, that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes?
Yes, ma'am.
What plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Sentence you to adjudication and time served. No return to this location. All right, good luck, sir.
Thank you.
Lionel Beaumont.
Bonded, Judge.
Okay. Mario Serpis.
Bonded, Judge.
Malcolm Willis.
He's here present, Judge, I mean.
Mr. Willis, good afternoon, sir. You're before the court for one count of trespassing.
No problem.
The court does find probable cause. What does Mr. Willis wish to do?
Judge, in speaking Mr. Willis, he wishes to resolve this matter today.
All right, state.
Time served, no return, Judge.
All right.
He wishes to accept the state's offer.
All right, Mr. Willis, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Do you understand the proceedings you're in, sir?
Yes.
And do you need more time to speak with your attorney?
No.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Have you ever been treated for a mental or emotional illness?
No, I don't have any.
Okay.
Or I haven't been treated, or no,
Okay,
sorry.
that's okay. And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes?
Yep.
What plea do you wish to enter?
No contest, ma'am.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves adjudication and time served. Good luck.
Thank you, ma'am.
You're welcome. Jerry Durius?
Bonded, Judge.
Bonded, okay. How about Corey Green?
Mr. Corey Green is here, present, Judge.
I would need to have permission from the court to leave.
Here's Mr. Corey Green, Judge.
Okay, Mr. Green, you're before the court for one count of resisting officer without violence. Count 2 is operating without a valid license. Count 3 is not for magistrate, it's a seatbelt violation. Counts 4, 5, and 6 are traffic KPS matters. It looks like he's scheduled to be in front of his division judge on Monday. I do find probable cause.
Judge, our only request is, I understand 4, 5, and 6. He's going to see his judge on Monday at 9 a.m. I inform Mr. Green of that.
Yes.
I'm just going to be asking the court on count 1 on the misdemeanor offense. Would the court consider an ROR on that count alone?
Okay, I'll do that. All right, good luck, Mr. Green. Mr. DeCobo?
Steve, are you there?
Yeah, I'm here.
Okay. I have Mr. Amashi from the Miami Office of the Statewide Prosecution on the phone, Your Honor.
Okay, and did you have an opportunity to look at the affidavits?
I wasn't able to see the actual physical complaint, but the dates are, I think it's November 23rd, 2014. The address is, if I can look. This is the date that you just gave me. The date you just gave me is, if you can bear with me 1 second. The date you gave me was November 23rd, 2014. The address you gave me was 1750 East Las Olas Boulevard, Fort Lauderdale, Florida. That's what you just showed me.
Right. There's more paperwork. There's another date for February 7th, 2015 on the same address from your condos, 1750 East Los Olas. So it's a different date, different, it looks like different,
Can I see the actual complaint? Because this would, I think he was in custody. There's no indication he hit the same house twice in the statewide prosecution
Mr.
case.
Jacobo, here's what I'm going to tell you. All right, for, I understand that.
Can I have Mr. Amashi address the situation?
Right,
please?
but we don't have everybody looking at the same paperwork. And I don't want to make a decision. I certainly understand your standpoint. I don't want your client to be subjected to double jeopardy. Why don't we get all the paperwork, have it reviewed, have Mr. Amashi review them. I can reset this. It doesn't have to be done right this minute, because I don't want to be make a decision under pressure, not knowing all the details. Do you understand? I don't want your client to be prejudiced, and I would rather not do it this way.
Okay, I understand that, Judge. However, I would like to do it as expeditiously as possible. Mr. Gamboa has already served his time for the charges brought before this court in this case. And with all respect, I understand the court's position and the court's ruling. Well, I'll bite my tongue. Should have been alleviated a long time ago.
And
the Office of the State Attorney should have known that this was co-opted by the statewide prosecutor's office.
Okay.
There's no doubt in my mind it's the same act or transaction. I would stake my reputation, my license on that particular fact. Okay. So as quickly as we can do it is when I'd like to hear it.
Definitely. And I agree with you. And if he's supposed to be out, then he should be. But I'm not going to be pressured into making a decision because I don't know all the details. I don't have all the facts before me.
With you. If I were in your position, I would not do that.
So I know we're on the Friday. So
I'll come here tomorrow if you'd like.
So then I can reset it for tomorrow, and they can speak to whomever they need to speak to and review the paperwork. All right? And so
Are they going to be able? I live way down south in Miami. I don't mind driving. This is my job. This is what I do.
Right.
But on the other side of the coin is I would ask for the phone calls to at least be made. I don't want to come tomorrow and we didn't get around to it.
Well,
I have him. You can call him right now. I can give you his number.
Well, I'm not going to be here tomorrow. It's going to be another judge.
What's his number?
So they can take the information.
I'll inform the prosecutor who's going to be here tomorrow.
Well, okay. The statewide prosecutor's office number in Miami is 786.
Is this his personal number?
No, it's the office number.
78. But
is he going to be available tomorrow?
So you're not going to call today. You're going to call tomorrow. Is what it's
I'm saying if they are, I would. That's why give me the number.
We just set it for Monday, Judge. If Your Honor's back.
Yeah, I'll be here.
I can't ask Mr. Amashi to call on a Saturday. We're not.
No, that's why I'm saying.
Thanks.
It's either that the parties are going to talk to each other and communicate by email and put something in writing that this is what it is, or even if we reset it for Monday, I am going to require something in writing from the statewide prosecutor that this has already been. That he's already been charged and served his time on all.
With all respect to the court, I don't think we can accomplish this tomorrow.
Monday?
I'm sorry about that. I'm doing everything I can. If we can reset it for Monday, that would be fine.
That's fine.
Is that enough time to figure this out?
Yeah.
Or do you want Tuesday?
I'm gonna email. Eric is gonna be the prosecutor that's here. He's the one that's assigned to this courtroom. So she'll notify him because they work together every day. And if you can give us his number and his information on the side, and I'll provide it to Eric to contact.
All right. Take the statewide prosecutor's number, and maybe Tuesday, since he's not going to be over on the weekend, right?
Tuesday's probably better.
I don't want you to. All right. All right. Thank you. And hopefully we'll be able to resolve this to your satisfaction.
I didn't mean to be overbearing, but I think you were in my position. The court has been in my position, and I feel a sense of obligation and urgency when a man is in jail.
I understand.
Improperly.
Thank you. Tuesday. Let's do it for Tuesday. Yes. All right, Mr. Jacobo, do you speak Spanish? Because the Spanish interpreter is not here anymore.
Second generation.
He's smiling. I think he probably understands some. But Mr. Romero, if you could.
I did. He was looking at me the whole time asking me to translate. I was translating the best I can.
Okay.
But at the end of the day, I believe I told him it's reset for Tuesday.
Yes.
And he's hopeful everyone has their paperwork and he'll be released.
All right. Thank you.
Thank you.
Thank you.
Thanks, Mr. Jacobo.
All right. Dumo Briggs.
Mr. Briggs, come on up, please. He's a
approaching, Judge.
What's his name?
Briggs?
Page 8.
Briggs?
Yeah.
All right, Mr. Briggs, you're before the court for one count of resisting officer without violence. Count 2 is a misdemeanor capias, and count 3 is a municipal ordinance matter. I do find probable cause.
Judge, I did inform Mr. Briggs that on count 2 is a $2,000 bond. He's going to be seeing his judge on March 4th, and
He is.
he'll explain to his judge what happened. And depending on that, how that goes, then he'll be in a position to see if he can ask if he can be released on count 1. So, Judge, at this time, there's really nothing for us to request at this time.
All right, so then we'll leave this, and he'll see his judge on Monday. Good luck, sir. Waldo Belfort?
Mr. Belfort is here present, Judge.
Good afternoon, Mr. Belfort. You're before the court for two, it's traffic capias matters. What does Mr. Belfort wish to do?
Judge, this is a 2011 case.
Yes.
Right now, he's currently making payment plans. He has set up in Dade County in which he pays about $40 a month in order to get a valid license. Considering this is a 2011 case, Judge, I'm going to be asking the court to consider releasing Mr. Belfort ROR.
Oh, wow. All right, I'll do that. Good luck, sir. All right, David Welch.
Mr. Welch is here present, Judge. I mean, he's approaching. Come on up.
Good afternoon, Your Honor.
Good afternoon, Mr. Welch. You're before the court for a misdemeanor capias matter. It's on a trespassing charge. And you did not show up in court when you were supposed to. What does Mr. Welch want to do?
Judge, Mr. Welch has advised me he believes he resolved this case. I don't know if we can look in Odyssey.
All right. I'm sorry?
We're looking now, Your Honor.
Okay, thank you.
19120 and then 28. No, Judge.
Nope. This is a showing that he didn't go to court on February 11th. When does he think he resolved it?
When do you... January. Oh, when was the date of incident on this trespass?
January 17th.
January 17th.
Right, he never showed up.
Yeah, I spent the night in jail and took care of it the next morning.
He believed he got a time served. So if Odyssey doesn't reflect that, Judge, at this time, he wishes to resolve it. Maybe he was just ROR'd and he thought by the ROR maybe he got a time served, but he wishes to resolve it.
Right. All right, State, you have an offer for him?
Addition, time served, no return, Judge.
Judge, he wishes to...
All right, please raise your right hand, Mr. Welch. Do you swear affirm to tell the truth?
Yes,
You can put your hand down, sir. Do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Do you need more time to speak with your attorney?
No.
And do you understand that you do have the right to go to trial? By taking a plea today, you're giving up that right.
Yes.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes?
Yes.
What plea do you wish to enter, Mr. Welch?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. And your sentence, sir, is adjudication and time served. Good luck.
Good luck, sir. Now the case is over with.
No more. This is no more. All right. Michelle?
Here, President and Main Judge.
All right, Mr. Michelle is before the court for a traffic capias matter, and I'm told that his bond has been posted.
Oh, okay, yeah, he thought bond was posted, sir. Good luck.
Jarvis Jones.
Mr. Jones, here, President Main Judge. He declined service of public defender.
All right, Mr. Jones is before the court for count 1, grand theft. Count 2, violation of felony probation. Count 3, aggravated fleeing with serious injury. Count 4, failure to stop or remain involving a serious injury. That's 4 and 5 are the same counts. 6 is driving while license suspended, causing death or serious injury. 7 is possession of oxycodone. 8 is reckless driving, causing serious death or bodily injury. 9 is reckless driving, damage to person or property. 10, reckless driving, damage to person or property. 11, possession of cannabis 20 grams or less. 12, felony violation of probation. 13 and 14, felony violation of probation. All right, I do find probable cause. I just wanted to look at all the affidavits again. And does the parties wish to be heard as to, as to bond? Oh, Mr. Jones declined the services of the public defender. So he has several no bond holds. So on count 4, I'm sorry, you wanted me to put in a case number on something?
Yes, please, on count 13,
Yes.
it's 14010-035.
Okay, 14010. And then what else?
035.
035. CF10A. Okay. All right. So as to counts 3, 4, 5, and 6, I will impose 1,500 on each count, each of those counts. And then all the others are the standard bonds will remain in place. Count 8 will also be $1,500. And Mr. Jones, you'll be before your felony division judge on Monday at 8:30. Okay, Glenford Willis.
He's here present, Judge Amain.
All right, Mr. Willis, you're before the court. It's 1 count of resisting without violence, and then count 2 is a felony violation of probation. I do find probable cause, and the bond on count 1 is $100. You have a no bond hold on count 2, and you will be before your felony judge on Monday. Good luck, sir. Shaquem Charles.
He's here present, Judge Amain.
Mr. Charles has 4 court orders, which are no bond holds. Then count 5 is a misdemeanor capias with a $1,000 bond attached to it. I will leave the bonds in place. I was looking, I don't know when he's going to court on his other matters. All right, the KPS, the count 5 is a KPS on a battery charge, and then the other ones, Judge Ribolo signed the order on no bond, so I'll leave those in place. All right, sir, good luck. Johnny Dixon.
He's approaching, Judge.
All right, Mr. Dixon, you're before the court for 1 count of aggravated stalking, following, harassing, or cyber stalking. And on counts 2, 3, and 4, those are felony violation of probation. There are no bond holds. Does anyone wish to be heard?
They would be requesting, he's already being held no bond, so on that count, $7,500 bond would be what we would be requesting, Judge.
All right, as to count 1, I'll impose a bond of $5,000. And Mr. Dixon should be before his felony judge on Monday at 8:30. Good luck, sir. Brian Jones.
He's approaching, Judge. He's here at Main.
Mr. Jones, you're before the court for 1, 2, 3, 4, 5 counts of distributing or delivering cocaine. Count 2 is distributing or delivering fentanyl. And count 3 is possession with intent to sell or manufacture or deliver cocaine. Just a second. February 12th. All right, the court finds probable cause. Does the parties wish to be heard as to bond?
Yes, Judge. In speaking, Mr. Jones, I believe the bond which is currently set is $17,500. He's not going to quite be able to afford that. He's been living in Florida his whole entire life. He's self-employed. What he does for a living, Judge, is basically install tiles. He gets on a good week about $500 a week. Now, he lives in Fort Lauderdale with his aunt. He helps support his aunt. She is on a fixed income. She's on Social Security. Judge, from what he advised me, he has no money in the bank. He owns no property. Now, he does have a record, but it's dated. He's been clean for a couple of years now. Judge, we're going to be asking the court to consider a bond reduction. We're going to be asking on each count, instead of a $2,500 bond, we're going to be asking for a total of $1,000. That would be a $7,000 bond, which we're requesting on Mr. Jones' behalf.
Judge, I believe based on his history and his record and the charges, I believe the convenience bond is more than fair.
It's the history.
I believe he's been clean for 5 years, Judge.
says that in 2014, possession of cocaine with intent to deliver, possession of cocaine with intent to deliver, possession of counterfeit control, possession of counterfeit control, possession of cannabis with intent to deliver, possession of cannabis with intent to deliver. It says that he served 24.9 months. I'm not sure if that's, presuming that's prison, but I cannot, I'm trying to look it up on the Department of Corrections. I can't find him. He also has another possession of meth, possession of cannabis with intent to deliver, delivery of cocaine, possession of cannabis with intent to deliver, possession of cannabis less than 20 grams. It's a very long selling, Judge.
And speaking of Mr. Jones right now, he doesn't dispute that he went to prison. He did prison sentence. He served his time. Some of the priors that Mr. Jones informed me of that the prosecutor was reading off, he did where they were dropped. But Judge, he's been 5 years without picking up a new charge until these.
October of 2016. Okay. All right. I do find probable cause. I'm going to leave the bonds in place at $2,500 each count. Good luck, sir. Marcandy Joseph.
He's here, present, Judge, I mean.
All right, Mr. Joseph, you're before the court for operating without a valid driver's license, possession of heroin, and possession, count three is possession of cannabis 20 grams or less. All right, today's the short versions of probable cause affidavits.
It seems to be somewhat problematic. I can't tell anything from this probable cause affidavit at all. I would ask the court not to make a finding of probable cause. He stopped for a stop for no headlights, detained because of suspect cannabis in the ashtray. Okay. Search of the vehicle revealed 2 small capsule pills. We don't know where in the vehicle they were. We don't know whose vehicle it is. I think without some information, some basic fundamental information, that there really is no probable cause here. And if the officer who wrote this report, I guess certainly he didn't have time to type it or even write in between the lines, this is just...
It is more sentences than the ones we saw this morning. Because, there was one this morning with 1 sentence and the other one with 3 sentences, and now this afternoon, they've gone up a few more. But I'm not going to make a finding of probable cause because I have no idea what's going on here.
You're not?
No, not just based on this is what we found. I don't know what happened here.
It says, and I'll just make an argument for the record, Your Honor, that he was stopped at a traffic stop, defendant was detained, and it says that the cannabis was found in the ashtray, so it tells you the location of the ashtray, it was field tested positive on that. The defendant also admitted to not having a driver's license. The driver's license would have been even though it's coming in as it's not even coming in as a misdemeanor. I believe there's enough for probable cause. If there's not, I'm requesting time for perfection, Judge.
I'll give you that time, because if I continue to do this, we're going to have a problem. This is the 3rd one today, so.
I'm going to ask you to ROR, Mr. Joseph.
What kind of prize does he have?
Nothing, Judge. I can't find anything.
All right, I'll ROR.
Is it for to ROR? Are you finding probable cause then?
No, I'm not finding probable cause. I'll get you. You did ask for 24 hours to perfect.
Yeah, there's no point now if you're RORing. So.
Okay. All right. Edward McLeod.
He bonded, Judge?
Oh, you want me to write it? Yes. Well, here's the thing. Well, he's already RR'd. He's gone, so. Oliver Townsend.
Mr. Townsend's here at Main, Judge?
All right, Mr. Townsend, you're before the court for one count of possession of drug paraphernalia, and count 2 is an out-of-state felony hold. And I do find probable cause, and you'll be before the court, the extradition court next Tuesday or Thursday for your out-of-state felony hold. Good luck, sir. Jannard Murphy.
Paul Ron, Your Honor, he chose not to join us this afternoon.
All right, well, we'll reset.
Okay.
Christopher Davis.
Mr. Davis, come on.
Mr. Davis, you're before the court for one count of possession of methamphetamine, 2, possession of cannabis 20 grams or less, 4, possession of drug paraphernalia, and 3, possession of drug paraphernalia. 4 is not for magistrate, it's a traffic infraction. And the court does find probable cause. What does the parties wish to be heard as to bond?
Judge, in speaking to Mr. Davis, unfortunately, no one's going to afford to post his monetary bond. Right now, he's homeless. He does have a mailing address. He works in landscaping, and he's helping his ex-wife with some of the things that she is going through. So he really wants to be out there so he can work, still provide for his ex-wife. He's 26 years old, been living here his whole entire life, so he's asking the court to consider releasing him on pretrial release.
Judge, I'm requesting that the convenience bonds are more than fair, Judge, based on he has prior histories, trafficking in 3 to 4 MDMA, 10 to 200 grams, possession of cannabis. Back in 2000, the first one was 2010, Your Honor. The second one was 2012, the possession of cannabis. And I see also a 2019 possession of drug paraphernalia and loitering and prowling. And I do see unless this is the open case, the 18773. So he has another open case for possession of drug paraphernalia.
I'm gonna leave the bond in place at $1,000. Good luck, Mr. Davis. Rudlin Ima.
North Broward.
All right, Mr. Ima is before the court for 2 bond surrenders. Is it because of a change of charge? Or is it just a regular, what is going on here?
Original bonds were $2,000.
I'm sorry?
The original bonds were $2,000.
On each
you
count?
You can keep that, Judge. That's fine.
He also has a $15,000 bond on count 1.
Okay. All right, so I'll impose the bond, $2,000 on each count.
All right, Mr. I'm going to call your mom for you, okay?
All right.
All right, see what she can do about bond.
All right.
All right, sir. James Brinkley?
And Your Honor, I have to apologize. On that Christopher Davis case, I just want to correct the record for the court. On the 18-000-773 MM30A, the possession of drug paraphernalia, it is not an open case. He resolved it back on June 1st, 2018 and received an adjudication withheld.
Okay.
I just wanted to correct the record.
All right, thank you. James Brinkley?
Yes, ma'am.
All right, Mr. Brinkley.
Say Paul.
Is Mr. Brinkley represented by the Public Defender's Office? Mr. Reedy?
Hi, Judge.
Is Mr. Brinkley represented by the Public
Yes,
Defender's
Judge.
Office?
He also has a no bond hold as a parole violation on count 6. So we'd ask the court to keep that into consideration when setting a bond for Mr. Brinkley on counts 1 and 3.
It was found no bond on that.
All right, so,
Still.
so these are counts 1 and 2. And you're saying count 6 has a no bond hold?
1 and 3, Your Honor.
No information. They just going by the police report. They got no information. I believe 30 something.
You know, Wikipedia says 2 and 1. I was looking at the.
That's very different. That's it. That is completely a different person.
See?
Your Honor, that's
James Brinkley?
It does not look like
That's
Mr.
not
Brinkley.
him.
That's not like.
My name, I'm at Paul Ryan, ma'am.
He's at Paul Ryan. Okay.
Oh, well,
Sorry.
I guess there he is.
I
That
was
looks
like,
more
who
like
is
him.
that? All right. All right, state.
Your Honor, this is just a change of charge. On count 1, I'm requesting a $100,000 bond, and then the kidnapping, it's a PBL, no bond, Your Honor.
In light of the fact that Mr. Brinkley is being held no bond on count 6 and count 7, which are violations of parole and a parole violation, we would reserve any argument regarding bond until such time as Mr. Brinkley can appear before his division judge.
All right, so 100,000 on 1, and he'll remain no bond on 2, on 3, even though this says 2 and 1. 3, right? Okay. All right, Mr. Brinkley, you'll be talking to your attorneys about your case further. Yes, sir.
Your Honor, I got ready at 33 days. I got almost 33 days in. Monday will be 34 days. I've been here. I ain't seen no magistrate. I have not been arraigned. I haven't been to arraignment or nothing. I've been sitting all this time. I've been sitting since January the 29th.
Well, you must have been to some magistrate before some magistrate.
No, ma'am, I haven't. But when I first came in, that's the only judge I seen. After that, I ain't seen nobody since, ma'am.
Right. So you saw a judge when you came in.
Ma'am, came when I first came to first appearance. But I've been locked up 33 days since then.
Right. Because you have no bond hold, sir. That's why. All right. You have 2.
So what did they do on 1 and 2, ma'am? I didn't catch that.
$100,000 on 1 and no bond on 2. On 3.
Count 3, Judge.
3. I keep saying 2. It's 3.
$100,000 on 1. What you doing?
Antoine Jones. All right, Mr. Jones.
North Railway.
Mr. Jones, this is.
I'm sorry, ma'am, I couldn't hear you.
You're before the court for a change of charge. It's fleeing with disregard of safety to persons or property.
There's an original bond, Your Honor,
much was the-
$5,000. It's the same bond.
Okay. They've just changed the charge, but it's still a second-degree felony. So I'm just gonna we're gonna leave the bond. It was $5,000 on the original count, so it's $5,000.
Judge, I understand that this is pretty much a maybe a lateral change. Nevertheless, Mr. Jones advises me, not only as the court can see, he has a device around his neck because he has a very serious heart condition. He also has a $1,000 bond on count 4 and a $100 bond on count 5. Everything else was no info on his case. I'd ask the court if the court would consider a $1,000 bond on count 3.
How many counts were there originally? You're saying
7.
somewhere no info?
Count 1, failure to obey an officer was no info. Count 2, reckless driving was no info. Count 3 is the one we're here on today. Count 4 is a grand theft auto, that's a $1,000 bond. Count 5 is resisting without violence, that's a $100 bond. Count 6 was possession of cocaine, that was no info. Count 7 was drug paraphernalia, that's a $100 bond.
Oh, Judge,
Go ahead.
I actually have this case. He's set in front of my judge on Monday, in front of Judge Shear.
You are the prosecutor
I
on
am the
this
prosecutor
case?
on this case, Judge. So I'm requesting that the bond stay the same until, and if there's any arguments by counsel, it could be made in front of the judge that's presiding over the case.
All right, I'll leave it at 5,000.
I'll make that phone call for you, Mr. Jones, okay?
All right, thank you.
All right, Cedric Wimbley.
Conti. How's your day, Your Honor?
How are you, Mr. Wimbley?
Okay.
Mr. Wimbley is also here for a change of charge to a burglary of unoccupied, unarmed.
Your Honor, this is a change of charge. The original bond was $1,000. I'm gonna request that the bond stay the same, Your Honor.
Okay.
Wembley has a $100,000 bond on count 1, so
All right.
I guess a $1,000 bond on count 3 is not the most objectionable thing.
All right, so we'll leave the $1,000 bond. Good luck, Mr. Wimbley.
Your Honor, can I ask one question?
Yeah. Yes.
Yes, I had 2 robbery with a firearm charges. One was changed to grand theft 300 under 5,000. And my mom has lupus. She's taking care of my kids, and there's no way she can pay a $100,000 bond to release me to get my kids. So I was wondering if there's anything that we can do today. My lawyer put in the bond motion. I don't know what happened. She did it on the 25th of January, and I've been waiting to see what could happen with that.
All right, well, that's not before me today, sir, so I can't make any rulings on that today. So you may want to follow up with your attorney on the motion. All right, good luck, sir.
All right, thank you.
You're welcome. Diego De La Torre.
Paul Ron, Your Honor.
Hello, ma'am.
Hello, sir. Is Mr. De La Torre represented by the Public Defender's Office?
Let me check, Judge. Why don't we could ask him. Do you have a lawyer, Mr. De La Torre?
Yes, sir.
Who's your attorney?
Daily Set Riello.
What's his last name?
Riello.
Do you know how to spell that?
Riello.
Let me see if I. Does he know you have court today?
I don't know, sir. I'm not sure.
Is it a man or a woman?
A woman, sir.
She's out of Miami?
Yes, sir.
All right. Did Mick put her on recall? Let me give her a call.
All right, thank you. We're gonna see if we can find your attorney, sir. We'll recall your case in a moment. Andre Newsome.
North Broward.
Also North Broward. Andre Newsome.
And Your Honor, before I'm looking at this case, the 19149 case, that we're just on. According
Yes.
to Odyssey, his attorney is actually the public defender's office, Stephen Dobrinsky. He's in front of Judge Michael Lynch. I don't see any notices of any attorney filings.
Are you talking about De La Torre?
Yes, Your Honor.
Okay.
So I do not see any other attorney. I only see that he's represented by the public defender's office, and his next court date is March 4th.
Okay. Well, we'll see. Is Andre Newsome at the North Broward?
Yes, he is, Judge.
What docket is he on, Your Honor?
He's an add-on.
Oh, he's an add-on.
I don't know that.
Nobody told the jail.
Sure didn't. Let me try to find him, see if I can get him down.
Okay, thank you. All right, then we can go to the felony hearing docket. We'll see what we can accomplish there. It's Travis Barlow. Travis Barlow. All right. Okay. All right. And then Travis Barlow, Mr. Barlow was arrested on January 27th. State?
Your Honor, the case has been filed today.
It was filed today? All right, Mr. Barlow, you were brought before the court for a motion for release, but the state has filed the charges, so there's no action for me to take today. Good luck, sir.
Is there any way I can take a plea today?
No, they are felony charges. You can't take a plea here. You have to go to your division to do that.
Do you know when my court date will be?
No, is he scheduled for? No, I don't have that information. Sorry.
Thank you.
Daniel Sobush.
Mr. Sobush is here, President Main Judge.
All right, Mr. Sobush was arrested on the 26th. It's a second look.
He has $1,000 bond, Judge, on a drug offense.
Yes.
Judge, this time, unfortunately, he's homeless, and there's nobody that's going to be able to post his monetary bond. Right now, he works handing out flyers, and what he's also done is applied at Doughboys. So he's hoping when he gets out, he wants to see if basically they've already looked over his application. Hopefully, he's employed. But Judge, he's been here his whole life, so we're asking for the court to consider releasing Mr. Sobush on pre-trial release, and we wouldn't object to having Mr. Sobush basically subject to random drug testing.
All right, that's granted. We'll do pre-trial release with random drug testing.
Thank you, Judge.
Tiffany Sharp.
Mr.
No problem, John.
Yes, North Broward. Mr. Clayman is standing by phone, Judge.
For Tiffany Sharp?
Yes.
Okay.
Hello, Judge.
Hi, Ms. Sharp. All right, Ms. Sharp was arrested on the 26th, and she's here for a second look.
Yes,
Her bond is, she has a $1,500 worth of bond. Is that correct? All right, Mr. Clayman is on standby. Is there something he wants to let me know?
Well, he's just available, Judge. He is her attorney, so if you wanted to talk to him, he's available to talk to you.
Okay.
The number is 954 603 1616.
When you said he was on standby, I thought you had him on phone.
No,
up there.
no.
Law office, may I help you?
All right, this is Judge Jackie Powell. I'm calling from open court in regards to Tiffany Sharp.
Hello, Your Honor.
Hi, is the attorney available?
Actually, I'm going to give you his cell number.
Okay.
Because he just walked out, 954.
Yes.
954-218.
Yes.
9140.
Okay.
Okay?
All right. Thank
All
you.
right, thank you. Bye-bye.
Right. I don't think Mr. Clayman. Mr. Clayman, this is Judge Powell. I'm calling you from open court.
Good afternoon, Your Honor. How are you?
I am well. I have Tiffany Sharp before me today for a second look on a bond status. And I was told that you were on standby, so I didn't know if there was something you wanted to let me know. She's got $1,500 worth of bond, and it's the administrative order that brings them back if they're still in custody, and so she's here.
I don't think that there's, correct me if I'm wrong, of course, but I don't think there's anything else that we can address now. I made my argument to you the last time, and I believe you found no PC for count 4, and the rest you found PC for, and you levied bonds.
That's right.
And forgive the noise, please, I'm driving.
No, that's okay. That's okay. Sometimes somebody has something else, I don't know, but because of the administrative order, they do bring him back for a second look.
Sorry for the inconvenience. I
No.
have nothing else to add.
All right, thank you.
You got it. Have a great day.
All right, bye.
Bye-bye.
Can I say something?
Yes.
Can I? Your Honor, I wanted to know if the option of me being RR to BART is available to being in the BART program. Your Honor, please. I understand I may have a little issue with drugs, but I am a good mother. I have been helping my mother with my children, but she does need me. But I understand that I do need to help myself first. But I don't think I can help myself being in jail. If you would allow me to be and listen to the BART program, to be released to them, or any other program that you see fit, I will assure you that I will follow through with it. I really want to get out so I can get myself together for my children. All right,
Miss Sharp, I don't want you to keep going on because there's not much else that I can do today as far as that. You need to have a conversation with your attorney so that you can work that out, okay? So I'm not going to make any changes today as far as the bond is concerned, and then you need to speak to your attorney about whether it's drug court or getting transferred to BARC or, all of that. Okay?
Okay.
All right. Good luck, ma'am. Oh, so who's her judge? Okay. All right. Okay. All right. Thank you. Yes.
This is Newsom.
All
How you doing,
right,
man?
thank you. Mr. Newsom, you're before the court this afternoon because there is a ad charge, for possession of Utalone. It's a change of charge. How much was the bond on it was $1,000?
Yes, Your Honor. The
So-
bond set is okay with the state.
So we'll leave the bond at where it is.
Mr. Newsom has no bond holds, Judge.
All right. Okay, Mr. Newsom. Good luck.
Excuse me, ma'am. I don't understand what just happened.
There's another charge. Count 5.
Mm-hmm.
And it's possession of youth alone. And so I've just well, the bond, we're going to keep the standard bond of $1,000 on that charge, on that count. Okay.
So the charge is changed.
Right.
What is that? I don't understand.
All right. Your attorney will explain it to you.
Youth law. What is that? I don't understand.
What was the original? Because it's not on this one. Usually it's there. All right. It's an ad charge, Mr. Newsom. So you'll speak with your attorney, okay? They'll explain.
It's an ad charge.
Yes.
Or a change of charge.
It's an ad charge for a position of youth alone. All right.
That's it.
That's it. That's it. All right, this is a misdemeanor docket. Sobush, which one? Thank you. All right, we'll go to the misdemeanor hearing docket. Tony Sherrod.
Conti? Yes, ma'am.
All right, Mr. Sherrod was arrested December 31st. Is Mr. Sherrod in custody on other matters? Because this is a municipal ordinance matter.
Yeah, I got, I'm waiting to go to my program. This is the only thing holding me up.
Okay, and does that mean you already took a plea on something else?
No, they sent me to a program to my charges being filed on my other cases. So they sending me to First Step Sober House. And this the only thing that the judge released me to First Step. I'm waiting on them to pick me up, but they couldn't until.
Oh, I see. Okay, so you have a municipal ordinance matter before the court. I don't know.
It's an open container.
I know, but I just don't know why it wasn't resolved before.
I know. I've been here 2 months. Two months. Just for that, I don't know. It's a $50. It's a $25 bond, but I couldn't reach my family members, so and they done enough. I can't make the $25.
Okay.
He has two pending cases, Your Honor. The 19-0001 CF10A in front of Judge Duffy. It's a felony case. His next court date is March 28, 2019. The next case that he has, Your Honor, is 18-13068 CF10A, and that is also a hearing says violation of probation, a possession of cocaine on that. So he has a VOP pending and an open case pending, Your Honor.
All right. And maybe this was not resolved because and looking at what we have today, I don't know the date of the other offenses. Maybe there was concern about points or something. I don't know.
I was on the bicycle.
What?
Oh, I thought you meant putting. I was on the bicycle.
No.
When they gave me the open container.
I don't know. I don't know anything about the bicycle. But since you have he's got a no bond hold.
No, I'm going to
on the violation.
Let me check right now.
He's not in custody. The only thing holding him here,
yes,
keeping him from the program is this charge.
Okay, all right. So, Mr. Sherrod, do you want to resolve this case today?
If I plead guilty or not, it's going to violate my probation, right?
Well, I guess that was the reason why it wasn't resolved before. So it's not a plea, it's just that pending the resolution of whatever he's been sent to. All right. So we're not going to take any action on this then. I don't know.
You can RR me if I can go to my program.
Which program is he going to?
Custody to
They're
custody.
it's gonna be a custody to custody?
Yeah, that's what I'm looking
All
at
right.
in the order right
Okay,
now.
then I'll
And there was a-
ROR you on this, and then you'll be transferred, okay?
There was an order.
Yes, ma'am. Thank you.
All right, good luck.
Yeah, there was an
Thank
order on
you.
February 27th that Judge Duffy signed. RR to PTR level 02 GPS waive. Custody to custody, first step sober house.
Okay, all right, good. All right, thank you.
So I can go to my program now?
Yes, sir.
Thank you.
Yes. Clinton Allen.
No problem, Your Honor. Good afternoon.
Good afternoon. There's always so much mystery going on with each of these. We have to decipher it. Mr. Allen is before the court. Mr. Allen is for a second look. He was arrested on February 26th, operating with... Is Mr. Allen in custody on something else?
Judge, he had his probation reinstated, it looks like. So I think this is the only thing holding him at this point. Is that correct, Mr. Allen?
Yes, it's a suspended license, sir.
No. Do you have another case?
No, I don't, ma'am.
Mm. Right, which is this one. That's before. Is there showing anything else? That's any other thing that's holding him in custody? All right. All right, then I'll RR Mr. Allen on this charge.
Keep track of your court dates, Mr. Allen. Don't miss court.
No, I won't, sir.
Okay,
All right, good luck, sir.
Thank you, ma'am. Have a great day.
You too. Devin Hyman.
Conti. Hello, how you doing?
Hi, sir. How are you?
All
All right, Mr. Hyman was arrested March 8th. And is there something else holding Mr. Hyman in custody?
Yes, Judge. Count 8 is a no bond violation of probation. Count 9 is a no bond out of county hold. What I'm not sure of is whether count 8 is an in or out of county violation of probation.
The only thing that he's waiting on is to be picked up from I think it's Dade County.
Okay.
But I guess they just saw him still in custody and thought like anything about that. But everything's
Okay.
just waiting on him to be.
So he's just
okay.
waiting.
All
Okay. All right. Mr. Hyman, you're just waiting to be picked up by Dade. There's nothing else for us to do today. Okay?
So do you know how longer they'll come when they come?
I don't know. I don't.
So is the I'm thinking I had a bond, but I think my lady she posted it right. It went from 100 to 25, and she posted a bond, right?
Okay. So there's nothing else that's holding you except for Dade County to come and pick you up. Okay?
All right, thank you.
All right. Bernard Davis.
Paul Ryan, Your Honor.
Mr. Davis is in for possession of drug paraphernalia. Is there something else holding Mr. Davis in custody?
Count 2 is a possession of substitute cathinones. It looks like he got a pretrial release Elmo on that. Maybe pretrial can help us out.
Anybody knows on Mr. Bernard Davis?
He did get retrial with GPS for the 18 felony, so the only thing that's holding him is the drug test.
All right, so I'll ROR him on the drug paraphernalia.
Thank you, ma'am.
All right.
miss court, man.
Don't miss court, and, but he's still, is he with an ankle monitor? Oh, okay, all right.
Okay.
All right, sir, good luck.
Good afternoon.
All right. Did we find out anything, or do I need to just proceed with,
I think we
Mr.
probably need to
Delatorre?
proceed, Judge. I left a message for Miss Riello. I have not heard back from her. I can say that our office interviewed Mr. Delatorre yesterday.
Yes.
He advised he had hired private counsel, so the interview was concluded.
Okay.
So I don't know how the court wants to proceed. Right now, it appears that the public defender's office, we are the attorneys of record.
Okay. Then let's proceed then. He was at the main jail, or
No, Judge, he's at Paul Ryan.
All right. All right. Diego Delatorre. Officers at Paul Ryan, did you send Mr. Delatorre back?
That's where I thought he was.
Oh.
Yeah, that's what a BSO pic says.
I'm sorry, Your Honor. Do you need him back?
Yes, we didn't. Okay.
He went back there to be about 5 minutes.
Okay. Yeah, we said that we were gonna recall because we were just checking to see on his attorney.
I know you're trying to reach his lawyer. I'm sorry, ma'am.
Oh, okay. All right. No problem. Did we finish everything on the hearing docket? I believe so.
Is this the last case for the magistrates?
All right, Mr. Delatorre, you can come on up, sir.
Hello, ma'am.
All right, we weren't able to get in touch with the attorney that you had, but these are just, these are change of charges from counts 2 through 16. And previously, we did make a finding of probable cause, and there were bond amount of 2,500? 25,000 on each count with pre-trial. So I am going to impose, reimpose those bonds on each count, and you'll be in touch with your attorney. We made phone calls and we weren't able to get that person, the name that you gave us, okay?
I'm gonna try her again anyway, okay?
Okay, yes, sir.
All right.
All right,
Good luck, Diego.
sir. Take care.
Thank you, sir. Thank you, ma'am.
All right.